22 states are now suing the government over President Trump's decision to end birthright citizenship.
Birthright citizenship is the idea that children born in America whose parents are undocumented immigrants automatically gain citizenship.
Birthright citizenship defenders tend to point to the 14th Amendment of the Constitution.
The specific clause often cited within that amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." Senior legal fellow at the Heritage Foundation, Amy Swearer, however, disagrees with the notion entirely.
Swearer, in the abstract of her 75-page paper on the topic, writes, while it is indeed clear that the Constitution recognizes that citizenship is the birthright of certain U.S.-born individuals, both textualist and originalist analyses of the Citizenship Clause substantially undermine assertions that birthright citizenship must be applied universally to all persons born on U.S. soil, regardless of the immigration status of their parents. Joining us now to dive deeper into her point of view is Amy Swearer. Amy, welcome to Rising.
Hey, thank you so much for having me.
So why don't you elaborate on your argument? For years we've heard that it's pretty unambiguous that that even if you've come to the country illegally, if you give birth here, your children are American citizens from birth. But you say it's more complicated than that. Can you explain why?
Absolutely. So I'm fully aware that many Americans today, and in fact, probably most legal scholars, simply assume that we have what I'd refer to as universal birthright citizenship, that we follow sort of the old English common law that universally grants citizenship to anyone born in this country under any circumstances, except for maybe the children of like foreign ministers, foreign ambassadors, etc. But the reality is, when you look at the original public meaning of the 14th Amendment, when you look at what these words meant to the people who drafted and ratified that amendment to the Constitution, they were very clear. While they were trying, of course, to override the Dred Scott decision and make citizens of the newly freed slaves, that the Supreme Court in Dred Scott said they're not citizens, they can never be citizens, even though they owe their allegiance nowhere else, Congress was absolutely trying to make citizens of them and to eliminate permanent racial barriers to citizenship. But they were also explicitly trying to exclude certain classes of people, not based on race, but based on their lack of total, complete political allegiance to the United States that didn't put them in anywhere near similar footing to those newly freed slaves who owed their allegiance nowhere else.
But Amy, I want to get on to another case on the legal point of this, and I know you're aware of it because you allude to it in one of the pieces that I read, which you wrote. An 1898 Supreme Court case, which I'm sure our audience will be delighted to plunge into, but it's the US versus Wong Kim Ark. And to explain that briefly, this is about a 21-year-old person who had been born in San Francisco to Chinese immigrant parents. And his parents at the time, by virtue of being Chinese, there were a lot of restrictionist laws and they could not become citizens. He left the country and was not allowed back in because they said he wasn't a citizen. And he took that case to the Supreme Court. Now, before I go on to describe the judgment, is that basically an accurate summation of the underlying case?
Yeah, that is exactly what happened to Wong Kim Ark, yes.
So then, when it comes to the Supreme Court, they rule in his favour by a 6-2 majority. And Justice Horace Gray, for the majority, writes that the case, and I quote, affirms the ancient and fundamental rule of citizenship by birth within the territory. And he then goes on to say that the 14th Amendment is declaratory in form and enabling and extending in effect. So, I mean, that seems pretty clear to me. You obviously don't think that that applies in this case, but the language seems fairly clear. So what is your argument to counter that?
So if that were the only language in that opinion, I'd probably agree with you. But the reality is that opinion doesn't actually follow in its own practice what the common law analysis would have been. So at common law, that analysis from that court would have been very simple. It would have been Wong Kim Ark was born here. He is not the child of an ambassador or any sort of legally accredited foreign national. Therefore, he is a citizen. Instead, the court very narrowly holds and repeatedly emphasizes the lawful permanent residency of Wong Kim Ark's parents. That is irrelevant to anything under the Old English common law. And so actually my thesis within the article that you mentioned is that what the court is doing is sort of recognizing an Americanized version of that common law. And I think to that extent, that limited holding that the U.S.-born children of permanently domiciled, lawfully present aliens, what we would today consider lawful permanent residents, that they are U.S. citizens, I think that's perfectly consistent with, one, what the original public meaning of the 14th Amendment was, but also with this idea of this Americanized jus soli, this Americanized birthright citizenship, which is not nearly as broad as the Old English common law. And you see this even in a Yale Law Review article from that same year commenting on this case, where it recognizes that unlike the Old English common law, where even being a temporary sojourner was enough for the child of that person to be considered a citizen of that nation, the American common law doesn't allow for that. That permanent domicile, permanent residency is what makes that U.S.-born child a citizen. And so even after this case, you see scholars understanding that whatever the court is doing here, it is not embracing the full extent of English common law. To the extent it is embracing common law, it is an Americanized version of that. And I think that's perfectly consistent with both the Civil Rights Act of 1866 and also the original public meaning of the 14th Amendment.
So this executive order is going to get litigated. Immigration rights groups are suing to stop it. What would end up being the legal status of, so would this would render as not citizens anymore people, would this be backward as well as going forward?
So my understanding of the executive order is that it is only prospective. And I think that's a good thing, legally speaking. I think if you start looking at stripping citizenship from people who have already relied on that, who the United States has already said in good faith, we're considering you citizens, you start running into reliance issues. But this only looks prospectively for children born after a certain date. I believe that date is the end of February of this year. So it is prospective. The legal status would be after that the U.S. would not consider those children to be U.S. citizens. That said, almost never would that leave a child stateless. I know that this is an argument that has been put forward by critics of this executive order, but the reality is that almost always you are going to have that child either automatically qualify for or have automatically bestowed on them the citizenship of the nation of origin of their parents. In fact, I've not seen yet presented a single instance in which that wouldn't be the case, where you could, by some technicality of law and the fact of birth on U.S. soil, have an individual who just acquires citizenship nowhere if we don't consider them U.S. citizens. So I'm not sure that criticism is actually something that could even plausibly come to fruition.
Thank you so much for joining us today to discuss. We really appreciate it.
Thank you.